This is the biggest change in the recent times in digital business, and it has profound effects that will ripple down to all to the details, the detail level on all digital services. Once every single digital service that we do provide in the EU are affected with this. My advice, my 4 things, is that take this seriously. You need to start now. You need to plan the route, and you need to begin the journey, and you need to do it today. You need to start thinking about this. And if you doubt something, use professionals. This is not easy, unfortunately.
After 4 years of negotiations, the regulation was finally agreed last May. Interesting fact is that McKinsey, I think 6 months ago, said that the world trade based on the exchange and exploitation of data has surpassed the world trade in tangible goods like the things that you're sitting on, for instance. The regulation will start to apply in May 2018. It will replace the national data protection laws and the underlying data protection directive. Because it's a regulation compared to a directive, it will be directly applicable in each member state when it starts to apply. So key changes. So controllers is a defined term that means the entities or subjects that collect personal data and decide about how that personal data can be used. And processors are subcontractor that provides services to a controller. One of the most fundamental changes here is called accountability. It will be each and every controller's, and to a certain extent also processors' obligation to continuously show compliance with the regulation. In order to also demonstrate this compliance, so there's 2 things. You need to be able to demonstrate that you're compliant, and then you also need to kind of walk the talk. So it needs to be actually also so that you are compliant on documentation level, but also on a technical system level. So whenever you design a service or a product, you should keep privacy and the obligations that follow from the regulation in mind. You will have an obligation to report breaches of information security when it relates to personal data. Each controller has to inform at least the authority about the data breach. Whenever you outsource the processing of personal data going forward, you need to be very detailed in the contracts. So you need to basically be prepared all the time to show that you are compliant. So how to prepare to become compliant? This is an overview of how we see it as a law firm providing these kinds of compliance programs. So you have various areas. You have external communication, risk management, privacy processes, and internal instructions. There will be technical work to be done, documentation work, which mostly is done by us lawyers, and then there will be training that you will need to carry out. The bigger the company, the longer it takes to actually do this properly. And we would say maybe it's up to 6 months, depending on how agile the organization is to run through one of these programs. Technical changes like update your entire software infrastructure, then 6 months will not be enough.
First, there's the issue of documentation versus reality. This is how it's currently explained in their privacy policy. It says that we collect your data and we store it to our CRM. This is the real world. This is what actually happens, and it's okay. This is a good architecture. There's nothing wrong with it. It just doesn't reflect this image at all. In addition to this, there's staging environments, there's development environments, there are people's laptops. Privacy policies and privacy impact assessments, that's also part of now GDPR. Those are usually written by some project managers, maybe some developers are interviewed, systems engineers. Unfortunately, they're mostly done by non-technical people. You know, technical people, when you ask them into a meeting like that, where there's like non-technical people, 8 of them maybe, and 1 technical person, they're going to simplify. So you're not going to know what we actually do with the data, because we're not going to tell you. And that's not because we don't want to tell you, just we know that you don't want to hear it. Here's an external search engine that indexes all your data. This is pretty typical. What they all do is that they store your data into the cloud. They're on a computer somewhere, and you need to know where, because you need to explain where you're storing that data. Cloud logging services these days, these are also hugely popular. You might not know that you're using one. This is bound to contain some information. You want to make sure that it doesn't contain any personal data. Or if it does, then again you have to explain that you're using this kind of service and you're storing it somewhere. First you've explained where your data is, where it's actually stored, and then there's the concept of residual data. Because when you remove data from a system that is when it's going through, it leaves a trace. Let's look at it this again. There's the the simple situation where you have your maybe a form on your website and you store it to your CRM here. There are your web servers up front here, but before the web servers, there's usually some kind of caching layer. Then there are the actual web servers. They store a lot of logs. They have a local cache. Going forward, you have your databases. You have your MySQL logs. You have your binary logs on all servers. When they do replication in between each other, they actually store all the traffic that's going to the databases to all the servers, including the backup. Those binary logs will contain that personal information, regardless of whether you remove it on the database or not. Then there's the integration platform, as I said. There's logs and local caches, and they usually use a different database, and that database too has its own binary logs that it stores, where it stores all the data. Then you have your SaaS services, so software as a service services. Those are cheap, easy to use, convenient, and they store all your personal data. Then there's their CRM, your actual CRM, the backup of that CRM, the development environment, logs, data flows. They are complicated, where you have these many places where you store that data. Removing that data from there is going to be a tricky endeavor. Then there's the whole thing about electronic format and data aggregation. Most systems don't have data optimized for aggregation. They're spread out to optimize the functionality of the system. So you don't aggregate your data by default. So if you want to gather them in a single electronic format, it might be a really burdensome task to do when people start asking for that right to get that data in an electronic format. What I would suggest you guys to do is to think about ways that you can provide it as ready as you can. So what to do, basically, take the regulations seriously, that's what I'm saying. Map out your systems in full detail. Consider the aspects that I just said. Data flow through the system, cloud services, software as a service. Consider residual data. And for compliance, make sure your technical personnel understand what the legislation is requiring from you.
Now, rights to individuals, what is old, what is new, and maybe also address a little bit what does it mean. There's a lot more on transparency. That's a fancy word for what you have to put in your privacy policy. Access to personal data, same here. It is now clear that you have 2 rights. First right, you may ask what type of data do you have about me? And the second question is you actually want to see the data. It means that if there is incorrect data, then you have the right to correct that incorrect data. The right to be forgotten, famous Article 17. Well, I'm actually thinking that this will not change much, because there were already rights to have your data erased in case it's outdated. And actually, if we look closer, and it gets maybe a little bit complicated, if you look closer, it's more about the right to be delisted than the actually erasure of the records. So data portability, that's actually a new right. The company that has the data currently should provide you with a machine readable record that you could use for the other system. My favorite one is the automated decision making. That's very new, and I think that has been a little bit overlooked in the discussion about the right to be forgotten and so on. The idea was that humans should not be submitted to decisions by machines without the possibility of human interventions when it matters. And then it matters would be legal or economic consequences. So if your money or your legal position would be worsened. A lot of things are open, and that's also something I think it's very important to take away. A lot of the provisions in that law are unclear because it's new. One of those things that are unsecure is kind of the one that really count, and where regulators have shown enforcement in the past and where we see statements, and what of those are things where they might not really care as much. I want to come to processors. What does the GDPR mean for processors? There's basically two roles that you could have. One is called the controller role, and one is called the processor role. The controller role is basically the one in charge. But often that's not how it works. Often you use certain services, cloud services, someone else's computer. I think that's a very good definition. Often you use those, and then they're called processors. The GDPR has obligations for both, and the big message is A, there's specific provisions, for example, what to put in a contract, which means you need to revise the contract. And B, now there are also compliance obligations for processors. One is that the controller may give instructions, and that has to be put in the contract. It's now also an obligation for the processor to take care of their own compliance. If you have a data breach, okay, maybe you'll hire some consultants, you'll hire some lawyers, but it will actually be relatively cheap overall. You pay a few thousand, maybe a few 10,000. That was kind of the risk. Now you could have, on top of that, you could have an authority actually coming to you and have those huge fines which were mentioned before in the introduction. So it's good to negotiate those clauses and obligations very closely. Well, that only leaves like a minute or so for the data breach, the third topic. Now it's going to be for all the business. So if you lose the data, and there's you will have to tell the authority, and then you will also have to tell individuals if there's a certain risk level. But here the data breach and the integrity principle says that also the unauthorized and unlawful destruction of data is a data breach that needs to be notified.
We get to a point then. So how does actually the users, or how this GDPR should affect the way we think about the users and the user experience that you have? When we take the role of the user, we realize that we use a lot of services, but most of the time as a user, you don't even know your rights. You have no idea what you can expect from the service provider. Then again, there's those people who actually might have a clue that, okay, I have some rights, and you might actually want to occasionally use them, but then again, you want to do it as smoothly as possible, and that's not always possible. But when we move beyond the law text, there's a couple of those things that as a user you can find out. These were the five that I actually think we can already start thinking about when we design these services for the users. So there is the review my data. I can ask for corrections for my data, and then to be forgotten. And then there's the leakage. How do I get informed if there is a leakage on the service? How am I able to ask transformation or to transfer my data for the other service? We have different kind of services, and we have these paths for them. So how those users go there. This is one example that you can kind of start mapping that, okay, we have the customer here on the pink, and his or she is having kind of interaction, and kind of point out each one of those interaction points where it happened. And once you start to collect those, you can start to kind of have this pattern that, okay, I have, before the person is actually using my service, there is probably some kind of registration or login. So what can I do there already? Then there's the touring time, so maybe you have some possibility to interact with the notifications with the user, or you have some kind of customer service point. Or then the afterwards, so when the person is already left your service, how do you actually provide them the means to be erasable, to be forgotten? These are just some of the ideas, but this is kind of what I wanted to point out, is that with looking through all the contact points, you can start to think where in those points you can say and educate the user as well of their rights and how they can use those rights. This is going to be one of those things that you have to look through the whole service you're providing. And it's going to be a lot about the communication, how you communicate things. The idea of the whole regulation is to get more transparent information and to get the people to know their rights. So I think this is one of the ways you can differentiate yourself from the competition as well. That you are going to be good with the regulation, but you're also going to be good with the users. And you're going to get better customer satisfaction because they know that you actually care about them.
The main point I think we are trying to make here is that you need to start acting now unless you have already started. I think it starts by understanding the regulation in like detail enough in order to understand, okay, how does this apply to my company? What are the things that we are doing in reflection to the new regulation? And then doing a kind of a gap analysis of okay, what are we doing nowadays? Where's our data stored? What are the processes? And then based on that, understanding, okay, what do we need to change? How do we get to the let's say to the bar? You need to get your management on board when doing this. So it's better to provide good understanding and good brief to your management. Okay, here's the thing. I figured out what is this upcoming regulation. Here's our situation, and here's what we need to do. Once you get that, it's time to execute within your own company, with your suppliers, with your partners, and with the help of the experts who actually can get you through this. How do I get to the first part, understanding? So we put together a kind of proposal for you. It's GDPR assessment, which helps you get started, and basically it covers both the legal aspects and the technical aspects we've been hearing today. And basically what it means is that we send out to you a questionnaire which we ask your company and then the relevant persons to fill in the information that helps us understand and assess what's the situation in your company in terms of different aspects that are relevant. Then we analyze it, and then we go together in a workshop where we actually go through in more detail, okay, what does it mean to go through a privacy program that helps you get compliant. And then we go through what did we learn from the assessment, from the questionnaire. And based on that, you get the understanding of what you need to do. Also helps you plan the next steps, the budget. That's pretty much what I wanted to say. So it's important to act now and start understanding what I need to do. And we have pretty concrete proposal on how we could help you get there. More information is on our website, exove.com/GDPR, and also if you want to make some queries, GDPR@exove.fi is helping. With that, I'd like to thank you all, and it was a really good morning here. Thanks.